In the Court of Appeal Civil Division, before the Master of the Rolls, Lord Justice Coulson and Lord Justice Nugee, in the matter of Britvic PLC v Britvic Pensions Ltd and another, case number A3 2020 0306 0316, Wednesday, 12th of May 2021.
Thank you. Before we start, let me just say a few things about the nature of the hearing. Obviously, this is a remote hearing, but it is no less a formal court hearing because of that, and those listening will obviously treat it as if they were in court. There is no photography or recording allowed except official recording. It's a good idea for everybody to keep their microphones muted. They're not talking so that we don't get the feedback that we seem to have at the moment with me, but hopefully when I shut up that will stop. And I hope you've agreed amongst yourselves the order of events, but if not, obviously we'll lay something down, but I'm sure that won't be contentious. It's a day and a half's case, and you may be assured we've read everything. I did send you an article that I wrote in the Canterbury Law Review, which concerns contractual interpretation a few minutes ago, or my clerk did, or was about to. It's shall we say, of interest in the context of this rather interesting case. And you can look at it overnight or over the adjournment, but it won't probably surprise anybody. And with that introduction, I'll just say we'll take a short 5 to 10 minute break mid-morning and mid-afternoon. And with that introduction, I'll ask Mr. Short to open his appeal.
Thank you, my lord. May it please your lordships, I appear on behalf of Britvic, the appellant and the principal employer of the Britvic Pension Plan. My learned friend Jonathan Chew appears for the first respondent, which is the trustee of the plan, and my learned friends Keith Bryant, Queen's Counsel, and Philip Steer appear on behalf of the second respondent, Simon Moen, who is a member of the staff section of the pension plan and who very kindly has indicated his willingness to act as a representative beneficiary, as he did below. Now, your lordships have, I hope, two bundles, a core bundle and a supplementary bundle, both as hard copies and PDFs. I am afraid your lordships using the PDFs will have noticed that the pagination is slightly out, but I will give the correct references for both the hard copies and the PDFs in the course of my submissions.
Thank you very much, Mr. Short.
There are also hard copy and PDF authorities. The hard copies in two bundles. There's one PDF, and there, I think due to Mr. Bryant's endeavours, the page numbering works exactly. We have discussed between ourselves the timetable, and the proposal is that Mr. Bryant will make submissions after me, and then Mr. Chew, and then a short reply from me. Now, your lordships will note this is an appeal from the decision of His Honour Judge Hodge QC on the 31st of January of last year. It's in the core bundle, tab 7 at page 76. The appeal, or the central to the appeal, is a short point of construction in relation to a rule dealing with increases to pensions in payment. It's Rule 10.2, although in fact it appears in the same material form in different sections of different deeds. The current form, following an amendment in 2008, is at core bundle tab 13F, page 156 of the bundle, page 160 of the PDF, and your lordships will have seen it's in, save for the parentheses at the end of the clause, it's in a relatively common form of pension schemes. It says the rate of increase is the percentage increase in the retail prices index during the year ending the previous 31st of May, but subject to a maximum of 5% in relation to pensionable employment up to and including the 30th of June 2008, and a maximum of 2.5% in relation to pensionable employment on and from the 1st of July 2008, and then in brackets the word central to the appeal, or any other rate decided by the principal employer. Now, in essence, the question is whether, as a matter of construction, the words or any other rate mean any other higher rate, as the learned judge found, or any other rate higher or lower. Now, just to get, or to introduce one piece of jargon, the practice of providing for increases reliant on the retail prices index or a similar index, but capped at 5% or 2.5%, is often referred to as providing limited price indexation, and so I'll refer to that as LPI, so that increases based on the retail prices index up to a maximum of 5% or capped at 5% is often referred to as 5% LPI, and that for convenience. The history of the rules is set, or this particular rule, is set out in some detail at paragraphs 14 to 28 of the judgment below, and that begins at PDF page 81, but unless your lordships wish me to, I'll simply summarise it here.
Well, you've no need even to summarise it, but are you content that it's accurate?
Yes.
Yes. I've just got one other question, Mr. Short. Are we getting a transcript of the submissions today?
My lord, I understand we are, yes.
Yeah, thank you very much. Just helps me for my note.
Yes, not contemporaneous, but I understand it should be available shortly after the close of play.
Yeah, thank you very much.
All I'll say then is that the directly affected members were formerly members of one of the two six-continent schemes. Those two schemes were formerly known either as the BAS Employees Security Plan or the BAS Executive Pension Plan. The BAS Employees Plan first included this rule in the BAS Definitive Deed and Rules of 1996, which is at page 129 of the bundle, page 133 of the PDF, and that's in tab 13A, where it's Rule 23. Now, my lords, I say directly affected members, and it's only those members of, or former members of the BAS Employees Plan who were still in service on or after this date, or on or after the date of the BAS scheme, DDR, which is the 26th of July 1996. But only those who were in service on this date are affected by this rule. Those who were either pensioners or deferreds at this date aren't affected by this rule. They are, however, indirectly affected because obviously the calls on the resources of the scheme have an indirect impact upon them. The executive scheme.
Can I ask you, Mr. Short, do we know what the previous pensions increase rule in the BAS scheme was, which dated back to 1946? I don't think we've got it in the bundles.
My lord, no, it's not in the appeal bundles. It was a rule, I think, that didn't have that power in it, but instead had a power for trustee to select the index.
Right. Thank you.
It-
Does that still apply then to those who left service before 1996?
It does.
Thank you.
It is also the subject of the M&B proceedings that are referred to.
Oh, yes.
In the judgment. So that's the focus of that. If your lordship wishes, we can provide the exact terms of the old power over one of the adjournments. But that was the gist of it. It's a 5% LPI subject to a right in the
change the index.
Yes.
It would be helpful to be shown it if you don't mind.
My lord will do that.
Could I also, at some stage, this may not be the most appropriate moment, I saw a reference to the M&B proceedings, but I'm afraid I haven't got my head around as to what, if any, impact those proceedings have on this scheme. They're obviously concerned with a scheme with what is now a separate scheme. But it's not clear to me, you'll have to explain it if it's important, whether they have any impact on this scheme.
Well, my lord, they have no impact on this appeal.
Well, I assumed that.
They have
That's quite the question.
Structure. My lord, no, I was coming on to deal with that. The question of whether they have an impact on the scheme is different. They may do, they may not. There are certain legacy members whose terms are directly linked to the terms of the M&B scheme. There may be issues that arise as to what that means, i.e. whether it was the terms at the point of transfer or the terms as they truly are, subject to any rectification. So there may be knock-on arguments, there may not, and of course that rather depends on what happens in the M&B proceedings, which I think is due to commence, the hearing is due to commence in June, 21st of June perhaps. Now the executive BAS scheme had a similar rule, but without the employer power. That's at page 131 of the bundle, PDF page 135, but I don't propose to go to it because it simply to show your lordship that the power isn't there. Following a business reorganisation, various businesses that were part of BAS were demerged, and the soft drinks business was spun off and became Britvic. And most of the members of the scheme who had been or were still employed in the soft drinks business, in colloquial terms, went with the business. And that included those who were deferred or pensioner members of one of the BAS schemes. As a result, the Britvic Pension Plan was set up with the two defined benefit sections, staff section and an executive section, to receive most of the relevant members of the 6-continent scheme. And there was also a defined contribution section for new employees. And that scheme was established by the definitive deed and rules of the 31st of January 2003. The key extracts are in the core bundle, although a more or less full copy of the deed is in the supplementary bundle at tab 5, but I'm going to refer to the core bundle, and it's tab 13D at page 138 or page 142 that the rules themselves start. Rule 10 is at pages 140 or 144, and your lordship see it starts. These are the staff rules, but the executive rules are in the same form. Each pension under the plan increases in each year after it starts to be paid, except, and there are some exceptions that need not concern us dealing with atypical pensions from additional voluntary contributions or an augmentation. Just pausing there, I should say that although taken literally, that would mean there would be an increase in every year. In fact, that isn't always the case, because that will depend upon the effect of Rule C.2 and the movement in the relevant indexes. So when RPI was negative, for example, there was no increase, even under Rule C.2, however it's construed. Rule C.2 then appears here. It's in the same form as it is now, but without the additional provision dealing with service after July 2008. 3 and 4, I think, don't really add much to the understanding of the rule. But 4...
Sorry, Mr. Short, I must be in the wrong place, because I'm in the electronic bundle at page 148. Is that where you want me to be? Because this version of C10 doesn't have a sub 4.
My Lord, I am sorry. I should have asked your Lordship to look at page 138 of the bundle 142 of the PDF.
142 of the PDF.
Yes, I'm sorry, 138 of the bundle, which is 142 of the PDF, is the start of the extract of the rules. And it's Rule C.2, for example, which I'll come back to, because that deals with a subsidiary issue.
Yeah, I've got C2, and then we go to C10 at the bottom of page 140 of the bundle.
My Lord, that's right.
Yeah, okay, good. I've got it.
And over the page, your Lordship has sub-rules 2, 3 and 4.
Yeah.
There's a particular provision in relation to the absence of GMP, which guaranteed minimum pensions, which doesn't concern us. And 4 is simply a prorating mechanism. There is the same rules apply to all intents and purposes under the executive rules. They're no different, but your Lordships note the PDF is at 146 and 148. The same provisions are readopted in 2007, and that's at pages 146 of the bundle, page 150 of the PDF, before they are amended into their current form in 2008 in the extract that I've shown your Lordships already. Now, in his judgment, the learned judge accepted, in my submission, that the literal meaning of the words in parenthesis was higher or lower, but taking various other matters into account, he found that it meant any higher rate rather than any other rate higher or lower. And it's that conclusion that is challenged at the heart of this appeal.
Do you say that if we concluded that there is only one available meaning of the words, in other words, that the parentheses are not ambiguous, that we cannot take into account, bearing in mind what Lord Clark said in Rainy Sky, we cannot take into account the ancillary matters that Mr. Bryant urges upon us and the judge accepted?
My Lord, I do say that, save insofar as the ancillary matters show that something has gone wrong with the language, but subject to that narrow exception, yes. certainly say that the starting point is the language, not because it is other than a unitary test, but one has to start somewhere, and it is the words that are being construed, and those words, I say, are clear and unambiguous.
What sort of material is admissible in order to show that something has gone wrong with the language?
That would include the contents of the document itself, but I would accept that it would also include relevant, admissible evidence as to the factual matrix, which may demonstrate, in an appropriate case, that a mistake of that nature has been made. It's not my submission that one is limited to the four corners of the document.
Well, I mean, that raises the question of when, because I'm bearing in mind Lady Justice Arden's strictures in Stena. She says you can construe it differently, the same clause differently at different times, but personally I find that rather hard to see. So let's take a sort of black and white example. Let's say that the letter sent to members said expressly that it was not intended that the employer could override the increase, and the clause said what it says. You would accept, even if that was after the clause had been drafted. In other words, the clause comes into being in 1996, but we're talking about 2003. You'd accept that's admissible context for the purposes of determining whether something's gone wrong with the language.
Well, it would depend on exactly what the document was, but I would have to accept, in the light of what Lady Justice Arden says in Stena, that the circumstances can be considered when it's readopted. If that information made clear that the intention was to change the existing rule.
I mean, it's quite odd to reintroduce a rule with the intention of changing its meaning in the same form.
Yes, it would be quite exceptional, but
especially if the contemporaneous material indicated that people were going to get exactly the same benefits as they had before.
Well, my lord, that's right. That's why I wasn't submitting that was this case.
Yes, I see.
Submission is very much that isn't this case, because the contemporaneous documents say same benefits or replicate. But if there were contemporaneous documents that said the intention is to depart from what happened before, and as a result of a series of decisions of the court, it's now apparent that X means Y, we are going to keep the old wording in order to introduce a new meaning, then that might tick the relevant boxes. But it's not this case. This case, I say, involved replicating the old rule, and nothing in the contemporaneous materials shifts that, either as a matter of construction, and certainly not by establishing that something has gone wrong with the language.
While we're considering, I'm sure you will come to it in due course, what happened on the transfer, can I just be sure the active members were given the opportunity to consent to the transfer and had to expressly opt in, were sent letters explaining?
Yes.
Presumably the deferreds and the pensioners were the subject to a non-consensual bulk transfer, is that right?
Well, that's right. So that the materials relied on here were sent to the actives who were being asked to consent, but not the others.
And presumably, well, is it part of your case that the rule must mean the same for everybody?
Yes. And well, even it must be the same in relation to those people who are not governed by it directly, because they are indirectly affected by it, because it affects the financial strength of the plan.
Do we have any figures for the number, as at 2003, the number of active deferreds and pensioners?
My lord, I don't think...
I think we do. I think I saw them somewhere. I can't tell you where.
There is some information about it in the witness evidence. I can give your lordships an overview. There are about 6,000 members at the time of the 2019 actuarial valuation. This was in the bundle.
If you look at page 206 of the supplemental bundle, it's when the proposal is being put by Mr. Jones to the pension trustees. That's the document I was thinking of.
So that shows 2,400 actives, 4,000 deferreds, 2.2 pensions in payment, 9,000 members. So it went down a bit by 2019.
Yes, and of the 4,000 deferreds, as I understand it, 3,000 or so were either actually deferred or pensioners. Putting those two figures together, about 3,000 or so had left service before 1996. So there are 3,000 people who are outside of this rule.
Yes.
Thank you.
My lord. But in addition to the words provided in my submission, the clearest answer here, there is no sufficient basis in the words and the other matters to establish any rival meaning. The other matters that I will refer to, which were taken into account by the learned judge, are these: the purposive construction, the factual matrix, and the legislative matrix. Now, of those, I say, in fact, properly analysed, they do not support, and certainly do not sufficiently support, the upwards-only construction, because, properly analysed, they either support the higher or lower construction, or they're neutral. But what is more, I say that the factual matrix is of limited weight in this type of case, i.e. a pension scheme.
That's because of Bernardo's.
Yes. Not only Bernardo's, but because of the various lines of authority are drawn together in Bernardo's. But many of the points made in Bernardo's aren't specific to pension schemes, but the fact that it is a detailed document produced by expert advisors is something that one sees even in the earlier authorities. But it is the point made by Lord Hodge in Bernardo's. Now, my lords, there has, of course, been the series of decisions of the Supreme Court in recent years, each one phrased slightly differently, but which make the same points as the Supreme Court has made clear. And I am going to ask your lordships to look at these now, starting with Rainy Sky. which is at...
Sorry, I mean, just to help me, I mean, do you say that that's correct, that they make the same point? Or do you say, this is why I've sent you this article, because I'm afraid it's always dangerous for judges to express themselves of views extra curially, but I suggest in this article that Lord Hoffman's points 4 and 5 in ICS have effectively been overruled by, without their lordships saying so, because they never say they've overruled ICS or that things have changed since Chartbrook, but actually the rule in Rainy Sky, which is then effectively confirmed. I mean, we could argue about the detail in Arnold and Britain and then Capita, is different, because as I put to you a moment ago, Lord Clark's perfectly clear that you need ambiguity, and you presumably say, well, whether they've said that they're overruling ICS or not, the law is to be found in Rainy Sky and following cases.
My Lord, I do. I think my submission was that the Supreme Court has said they are the same.
Yes, but the point, I mean, the burden of this article is that they're actually not.
Yes. My Lord, I'm not sure what I said is inconsistent with that. That's why I chose those words very carefully. And maybe that I can make full of...
Nicely done, Mr. Short.
I'm aware that this has come up before, my Lord. And it may be easier for me to deal with that once I have had the benefit of reading that article. But I do say the law is as set out in Rainy Sky, Arnold of Britain and Capita.
Yeah, okay, good. I mean, that's clear, and I see why you say it.
So,
do we go to Rainy Sky?
my Lord, yes, that's at tab 17 of the authorities bundle, page 351. And it's a judgment of Lord Clark with the agreement of the remainder of the Supreme Court, including Lord Mance, and I point that out simply because one can see that the constitution of the Supreme Court overlaps in this series of cases. But it's at paragraph 21 onwards, and it's 21, 22 and 23, to which I draw your Lordship's attention. Your Lordships have obviously seen these passages many times before. I'm not sure how best to deal with this. I could read them. I could ask your Lordships to read them to yourselves.
You're absolutely right. I'm sure all of us have read this, but what I find most useful anyway, speaking for myself, is if you just go to the bits that you say make the point that you're trying to extract from the case.
Well, my Lord, paragraph 21 refers to the situation where language used by the parties has more than one meaning, at which point, if there are two possible constructions, the court is entitled to prefer the one which is consistent with business common sense and reject the other. But at 23, Lord Clark says where the parties have used unambiguous language, the court must apply it, and that is a clear, the clearest of statements. Now,
and it, I mean, you know, I mean, I hate to bang on about this, but that is not what was said in ICS.
my Lord, no.
I mean, you do realise, Mr. Short, that you pulled a bad court in many ways, because I was counsel for the appellant in the Lords in ICS, and my Lord Justice Nugee was counsel for the winning party in Chartbrook.
Yes.
So we've been round this track. This court has been round this track quite a lot.
In fact, it's difficult to find one of the authorities in our bundle where a member of the court wasn't either sitting or at the heart. But, my lord, yes, but that is the statement of the law by the Supreme Court in Rainy Sky, and that's what I rely on.
Yes.
We move on.
I mean, does he say anything about the situation where extraneous material suggests something has gone wrong with the language in this judgment? I can't remember.
My lord, I don't believe he does. I don't believe he was dealing with that issue. That wasn't one of the submissions that was made. But there is no suggestion that he is seeking to depart from the authority in relation to something having gone wrong with the language, which is a different matter.
Well, it does raise the question, as you've just put, as to whether something's gone wrong with the language, which is taken from Chartbrook, is a separate jurisprudential analysis from choosing between two possible meanings, or whether it's at the end of a spectrum of choosing an uncommercial construction, rejecting an uncommercial construction where you've got two available meanings. And I think there is a question whether, certainly in the earlier authorities, it was regarded as a separate line of analysis, or whether it's just an example of the ordinary analysis, that you decide what the words mean having regard to their entire context, going back to what one might call the Hoffman theory of interpretation. So, but I think I detected from your submissions so far a suggestion that they fall into two different boxes. There's the box marked, there's two potential meanings, and then you can choose the more commercial one. But if it's unambiguous, you could still get out of that box by a different route, which is to say, well, that's what it means, but nevertheless, it's gone wrong.
Yeah.
Is that the way have I understood your submission correctly?
My lord, you have, or your lordship has, because it's often referred to as corrective construction. And there is in my submission something different between construing the words, saying this is what the words mean, this is the only meaning they can hold, or saying these words are ambiguous, but we find they mean X rather than Y because X is a possible meaning and it is the only one that makes business sense.
Yes.
And it is quite different to say, well, these are the words, but an error has been made, so that one isn't limited to those words because a mistake has been made and the court is correcting that mistake. But that is in my submission a slightly different, that's a different thing, simply to saying this is what the words mean.
Well, I see why you now say that, but I very much doubt that Lord Hoffman would have thought that he was embarking on some completely different type of exercise in Chartbrook from ICS, from any of the other cases.
My lord, I'm not disputing that necessarily, but what I would say is in Rainy Sky,
Yes.
Lord Clark was not dealing with that issue, and to that extent it is separate. Because I think one sees in Rainy Sky there was I think no consideration of that issue, the something has gone wrong with the language issue, which does call for its own particular analysis.
Yeah, but that's why I asked you what you can take into account in deciding that something has gone wrong with the language, because, I mean, obviously ICS was a case where something, according to the House of Lords, had gone wrong with the language, and there was good grounds on the face of the contract to say this in ICS. But here is rather different. Here we could only get to something being wrong with the language by looking at extraneous material.
Yeah.
And you said, well, your submission earlier was, well, you can look at any usual factual matrix or legislative context or whatever, but actually here that doesn't show something's gone wrong with the language.
Yeah.
That then raises the question of what is the juridical exercise, as my lord asks, that you're engaging in, because it is rather strange to, if you go through the process and say, do these words mean two things or not, and you come to the conclusion they mean one thing, you might reasonably think that Lord Clarke's first paragraph 22 or whatever it is applies, and you apply that meaning, and that's the end of the matter. And whether or not something's gone wrong with the language from extraneous material would be unorthodox and wrong. I mean, I'm not pushing you to say that, but it does.
Yes.
It is a more logical submission.
Well, I will consider the article perhaps and come back. What I will say,
And the article doesn't bear on this. I mean, all the article says, I mean, it's a bit of fun really, but all the article says is when Lord Hodge and everybody and Lord Newberger say that they haven't changed anything, is that really right? And would ICS be decided the same today?
yeah.
And the proposition is maybe not. But this case, I mean, the reason why I sent it to you is because this case really raises that question.
Yeah. Well, my lord, what I'll come on to Bernardo's in due course, and Bernardo's does still accept that this question, that something's gone wrong with the language, it is dealt with in a separate paragraph from the paragraphs to do with the textual. And I think
it's paragraph 17, isn't it? I think we've got to look at that quite carefully, because I'm not quite sure how that fits together with the earlier paragraphs that say quite clearly pension schemes are different and you apply the language.
Well, my lord, we'll come on to that in a moment. But perhaps before we do that, I was about to take your lordships to Arnold and Britain, which is at tab 22. And this is the judgment of Lord Newberger with the agreement of Lord Sumption and Hughes, also with the agreement of Lord Hodge, although Lord Hodge does give a separate judgment, which I'll look at as well. But it's paragraphs 15 to 17 in the first instance, which is page 489 of the PDF. And at paragraph 15, Lord Newberger sets out the task of the court when interpreting a written contract. The court is concerned to identify the intention of the parties by reference to what a reasonable person, in all the background knowledge which would have been available to the parties, would have been understood them to be using language in the contract to mean. The reference there is to Chartbrook, and at H onwards, he says that meaning has to be assessed in the light of the natural and ordinary meaning of the clause, to any other relevant provisions of the lease, 3, the overall purpose of the clause in the lease, 4, facts and circumstances known or assumed by the parties at the time that the document was executed, 5, commercial common sense, 6, disregarding subjective evidence of any party's intention, and then sets out the various authorities, including Rainy Sky, and then at 16, he emphasises 7 factors, the first of which is most important for my submissions, which is the reliance placed in some cases on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what parties meant through the eyes of the reasonable reader, and save perhaps in a very unusual case, that meaning is most most obviously to be gleaned from the language of the provision. Unlike commercial common sense and the surrounding circumstances, the parties have control over the language they use in a contract, and again, save perhaps in a very unusual case, the parties must have been specifically focusing on the issue covered by the provision when agreeing the wording of that provision. And then perhaps the second point. Secondly, when it comes to considering the centrally relevant words to be interpreted, I accept that the less clear they are, or to put it another way, the worse they're drafting, the more readily the court can properly the more ready the court can properly be to depart from their natural meaning. That is simply the obverse of the sensible proposition that the clearer the natural meaning, the more difficult it is to justify departing from it. Then goes on to deal with other matters which perhaps are less directly relevant here, although at 19, again, there's a reference to commercial common sense is not to be invoked retrospectively. So the fact that as things turn out, someone shouldn't have made a particular agreement or it turns out badly, that is no reason to depart from the language. Now, my lord, after Arnold and Britain, we have Wood and Capita, which is a...
You said you were going to show us what?
Oh, my lord, I did. I am sorry. I'm very grateful for your lordship reminding me. That is at paragraph 76 at page 501 of the PDF. Having agreed with Lord Newburger, he then says, 76, his conclusion. This conclusion is not a matter of reaching a clear view on the natural meaning of the words and then seeing if there are circumstances which displace that meaning. I accept Lord Clark of Stonecump Ebony, Justice of the Supreme Court's formulation of the unitary process of construction in Rainy Sky. He then sets out that passage, paragraph 21 of Rainy Sky, and then says this unitary exercise involves an iterative process by which each of the rival meanings is checked against the proper provisions of the contract, as commercial consequences are investigated, refers to Sigma Finance, and then says that there must be a basis in the words used and the factual matrix for identifying a rival meaning. The role of the construct, the reasonable person, is to ascertain objectively and with the benefit of the relevant background knowledge the meaning of the words which the parties used. The construct is not there to rewrite the parties' agreement because it was unwise to gamble on future economic circumstances in a long-term contract or because subsequent events have shown that the natural meaning of the words has produced a bad bargain for one side. The question for the court is not whether a reasonable and properly informed tenant would enter into such an undertaking. And then at 78, he says, nor is this a case in which the courts can identify and remedy a mistake by a construction, even if, contrary to my view, one concluded there was a clear mistake in the parties' use of language. It's not clear what the correction ought to be, what the correction ought to be made. Pausing there, he is there, dealing with this corrective construction separately to the unitary exercise of construction. I'm grateful, my lord, and that's, in my submission, particularly important given what's subsequently said in Bernardo's. In Wood and Capita, it is, which is at tab 26, Lord Hodge gives the judgment with the agreement of Lords Newburger, Mount Sumption and Clark. So one sees the overlap with the early authorities, and it's at paragraph 14 onwards.
Page, please.
I'm sorry, page 587, my lord, and perhaps paragraph 30 onwards, where Lord Hodge says textualism and contextualism are not conflicting paradigms in a battle for exclusive occupation of the field of contractual interpretation. Rather, the lawyer and the judge, when interpreting any contract, can use them as tools to ascertain the objective meaning of the language which the parties have chosen to express their agreement. The extent to which each tool will assist the court in its task will vary according to the circumstances of the particular agreement or agreements. May be successfully interpreted principally by textual analysis, for example, because of complication and complexity, and because they have been negotiated and prepared with the assistance of skilled professionals. So pausing there, that's a theme he returns to in Bernardo's, but not a pension-specific thing. Goes on to say the correct interpretation of other contracts may be achieved by a greater emphasis on the factual matrix, for example, because of their informality, brevity, or the absence of skilled professional advisors. Negotiators of complex form contracts may often not achieve a logical and coherent text because of, for example, the conflicting aims of the parties, failures of communication, and differing drafting practices or deadlines which require the parties to compromise in order to reach agreement. There may often, therefore, be provisions in a detailed, professionally drawn contract which lack clarity. The lawyer or judge, in interpreting such provisions, may be particularly helped by considering the factual matrix and the purpose of similar provisions in contracts at the same time. It refers again to the iterative process. And then the sentence, paragraph 14, on the approach to contractual interpretation, the Rainy Sky and Arnold cases were saying the same thing, which is, I think, what I referred to earlier. Now, there are 15. Recent history of common law of contractual interpretation is one of continuity rather than change. One of the attractions of English law's legal system choice in commercial matters is its stability and continuity, particularly in contractual interpretation. And that's the background, the line of authority which is then considered specifically in the pensions context in Bernardo's, which is at tab 28.
Just before you leave, the accuracy of the statement in paragraph 15 depends on how recent he meant by recent.
Yes, my lord. And I think in the context, one sees the context at paragraph 8 of the judgment, the context of that statement, and it always it's worth reading just to put terror into the heart of the advocate. But it says, in his written case, counsel for Capita argued that the Court of Appeal had fallen into error because it had been influenced by a submission by Mr. Wood's counsel that the decision of this court in Arnold and Britain had rowed back from the guidance on contractual interpretation which this court gave in Rainy Sky. This he submitted, of course, the Court of Appeals placed too much emphasis on the words the sale and purchase agreement to give insufficient weight to the factual matrix. He did not have the opportunity to develop this argument, as the court stated it did not accept the proposition that Arnold had altered the guidance given in Rainy Sky. The court invited him to present his case without having to refer to the well-known authorities on contractual interpretation, with which it was and is familiar. But it certainly, the court, that may indicate that that is what the court was particularly referring to.
Yes.
It says. So that may be of some.
There are rules, of course, about departing from a previous lord's authority, and there's never been a suggestion that any previous authority has been departed from, even though 1993 was 18 years before 2011.
Yes. My lord, yes. Barnardo's and Buckinghamshire, so that's at tab 28, at page 651 of the bundle of authorities, and in a pensions case, and indeed, as many of the construction cases are, a pensions case dealing with an increases rule, different increases rule. There are very many different increases rules, but they are ones that have very significant financial impacts, which is why they've seen a lot of litigation recently. The passages begin at paragraph 13. I should say this is again Lord Hodge, with whom Lady Hale, President, Lord Wilson, Lord Sumption and Lord Briggs agreed, and it's paragraph 13, which is helpfully at the top of page 657. And refers to the trilogy of cases, Rainy Sky Island and Britain Wood and Capita, giving guidance on the general approach to the construction of contracts. That guidance, which the parties did not contest in this appeal, does not need to be repeated in deciding which interpretive tools will best assist in ascertaining the meaning of an instrument and the weight to be given to each of the relevant interpretative tools. The court must have regard to the nature and circumstances of the particular instrument. 14 refers to the pension scheme, such as the one on issue in this appeal, has several distinctive characteristics which are relevant to the court's selection of the appropriate interpretative tools. And paraphrasing perhaps, first, a formal legal document prepared by skilled specialist legal draftsmen. Secondly, unlike many commercial contracts, it's not the product of commercial negotiations between parties with conflicting interests. Thirdly, it's an instrument which is designed to operate in the long term, defining people's rights long after the economic and other circumstances which existed at the time it was signed may have ceased to exist. And in my submission, those are general provisions or general comments that aren't specific to pension schemes, in that they will often apply to other types of documents as well, although they are comments that will almost always apply in relation to a pension scheme, certainly other than very, very small pension schemes. Lord Hodge goes on to say, fourthly, the scheme confers important rights on parties, members of the pension scheme, who are not parties to the instrument and who may have joined the scheme many years after it was implemented. Fifthly, members of the pension scheme may not have easy access to expert advice or be able readily to ascertain the circumstances which existed when the scheme was established. 15, judges have recognised these characteristics make it appropriate for the court to give weight to textual analysis, concentrating on the words which the draftsman has chosen to use, by attaching less weight to the background factual matrix than might be appropriate in certain commercial contracts. A long list of authorities, including, finally, Lord Briggs, giving the judgment of the Court of Appeal in Safeway against Newton, where Lord Briggs said this: the deed exists primarily for the benefit of non-parties, that is, employees upon whom pension rights are conferred, whether as members or potential members of the scheme, and upon members of their families, for example, in the event of their death. It's therefore a context which is inherently antipathetic to the recognition, by way of departure from plain language, of some common understanding between the principal employer and the trustee, or common dictionary which they may have employed, even some widespread practice within the pension industry which might illuminate or give some strange meaning to the words used. Lord Hodge goes on to say, I agree with that approach. In this context, I do not think that the court is assisted by assertions as to whether or not the pensions industry in 1991 could have foreseen and did foresee the criticisms of suitability of the Retail Prices Index, which later emerged in the public domain, or then thought it was or was not likely that RPI would be superseded. Well, pausing there, in my submission, these are general points of application to pension schemes. It is not appropriate, and this in my submission is one of the errors the learned judge made, to see whether there is any way in which any of those examples are not replicated in the particular scheme. So that the fourth point in paragraph 14 refers to members of the pension scheme who were not parties to the instrument and who may have joined the scheme many years after it was initiated. That's not a particular point to be checked in its own right. Why it matters is that scheme members may not have known what was going on, may not have known anything about the background. It really re-emphasised in the fifth point. And that may be because they joined several years later. It may be also because they are family members, as mentioned by Lord Briggs in Safeway. It may be, as in this case, that they were members who had left service, and so they weren't in contact, or they weren't sent particular party to, or weren't party to particular documents. But in my submission, it's not appropriate to see whether there are any elements, any examples as described in paragraph 14 that aren't replicated on the facts of a particular scheme or a particular question of construction when deciding whether or not to give weight to the textual analysis. So one certainly, the last example is members of a pension scheme may not have easy access to expert legal advice, and one certainly wouldn't construe a scheme differently because the members have access to, in a particular case, to expert legal advice or otherwise. But these are general points that will apply in large occupational pension schemes. Going on, moving on from paragraph 15 to paragraph 16, Lord Hodge says that the emphasis on textual analysis as an interpretative tool does not derogate from the need to avoid undue technicality and to have regard to the practical consequences of any construction. Such an analysis does not involve literalism, but a purposive construction when that is appropriate. And pausing there is a difference between a purposive instruction in this, what I call this courage sense, and taking into account background materials. And that's made clear at the bottom of that paragraph where Lord Hodge says, instead, the focus on textual analysis operates as a constraint on the contribution which background factual circumstances which existed at the time that the scheme was entered into, but which would not readily be accessible to its members as time passed, can make to the construction of the scheme. So I accept there should still, where possible, one avoids undue technicality, gives rules, one should give rules a reasonable and practical effect, but that's quite different to looking at extraneous materials. At 17, it says, as Lord Hodge says, it's nevertheless relevant to the construction of pension schemes that they're drafted to comply with tax rules. That's true. It's also, I would accept, relevant to the construction of pension schemes that they are drafted with one eye on the legislative background in relation to pension schemes. And so, for example, Section 51 Section 51 of the Pensions Act 1995, which deals with pensions increases to pensions in excess of guaranteed minimum pension, is relevant, albeit that I say it doesn't have the effect suggested by my learned friends or accepted by the judge. But then, finally, paragraph 18, Lord Hodge says this: finally, a focus on textual analysis in the context of the deed containing the scheme must not prevent the court from being alive to the possibility that the draftsman has made a mistake in the use of language or grammar, which can be corrected by construction, as occurred in Chartbrook and Persimmon, where the court can clearly identify both the mistake and the nature of the correction. And that is why I say there is a difference foreshadowed in Arnold and Britton. Is that right? Yes, foreshadowed in what Lord Hodge says in Arnold and Britton, between the corrective construction and the idea of departing from clear meaning where there hasn't been a mistake in the language.
What does he mean by where the court can clearly identify both the mistake and the nature of the correction? I mean, identify from what?
Well, ordinarily, it may be possible to do that from the language used in the document as a whole. But
I mean, this is not an invitation to overrule Penn and Simmons, right?
No.
I mean, the most obvious place where you recognise a mistake has been made is when one solicitor writes to the other solicitor saying, we're all agreed, aren't we, that clause X means Y, when in fact it obviously means Z.
Yes. It's not suggesting you can take into account negotiations or anything of that nature, but it may be from the language, from the document as a whole, it's apparent something has gone wrong somewhere. It may also be clear from the admissible background circumstances, not circumstances excluded by other rules of law.
Mr. Short, is it terribly old-fashioned to think that if you have words in a contract which are unambiguous, assume that the meaning of the clause in question is unambiguous, then if something has gone wrong, and so the unambiguous meaning was not what the parties intended, you seek to rectify the contract. It's not a question of construction at all.
Well, my lord, very often there will be an overlap between those matters.
Even where the language is unambiguous.
Well, yes, in fact, it occurs to me, and by way of example, most pension schemes are express defined benefits as fractions. So for each year you get 1/60. Occasionally, schemes daily rates, so you get a very small fraction of your weekly or monthly pay. But there are cases I'm aware of where a decimal point has been put in the wrong place, and that sometimes in two wrong places, and so that is an obvious mistake, and that is the sort of thing that can be corrected. The court isn't required to assume that someone gets a year's or gets a 2/3 salary after 3 years of employment.
But would an example be the case of Marley, where was it Marley where the wills were signed by the wrong people? And Lord Newberger said that's fine, it doesn't matter, we'll assume they were signed by the right people. It was an obvious mistake on the face of what was going on.
And I think for Manai, I think as well.
Manai as well, yes.
Where the date's wrong, and it's obvious from context what something was intended to do. And that, in my submission, is an important role, an important principle for the courts still to be able to correct obvious mistakes, but they must be obvious, and that is because the law, I think Chartbrook says you need a strong case. Other cases have made clear you need a strong case because the law doesn't regard the correct use and the misuse of language as being equally likely. One needs to show that something has gone wrong, obviously gone wrong, and can be corrected in a particular way. Could you do help the court with this, Mr. Short? I'm quite interested in this question of corrective construction, and it seems to me quite central here. And it would be helpful, I think, to track the cases which have said expressly they were adopting a corrective construction. I'm in two minds at the moment as to whether that was what ICS said it was doing. I don't think it was, but I can't remember sufficiently clearly. But there are cases, like you mentioned, Manai, Marley, and a number of cases where the court was obviously doing that. And the reason I'm interested is that I'm interested to try and explore what the Supreme Court has meant when it talks about this corrective construction as being, as you have submitted, in a separate category from the usual process. And I have a feeling, maybe wrong, that what you're now submitting may have some merit in the authorities, which is that it's actually only ever been expressly adopted in recent times anyway, but maybe also, I think the judge referred to some old cases, but it may have been only recently adopted in cases where the corrective construction and the answer itself was clear from the document, so that wills being signed by the wrong people, the decimal point being in the wrong place in one, or the date being wrong in one inconsistently with some other part of the document. I mean, all those things are very understandable, but what I'm concerned to see is whether there are any authorities which do what you submitted to me right at the beginning this morning, which is take the prospect of a corrective construction from factual matrix.
You might, in that exercise, Mr. Short, get some benefit from another case I lost, which was KPMG, where my recollection is I tried to run exactly that argument, what the Master Wills has suggested, but Lord Justice Commonwealth was unimpressed by it. And in that case, we had to construe a lease, which was plainly badly worded. But my argument was you couldn't tell from the face of the lease what the correction was, and he said, well, all you have to do is look at the agreement for a lease, which is admissible, and therefore you can find out what it should have said. So that may assist.
Well, I'm glad we have KPMG in the bundle of authorities.
Well, then you'll be able to see whether my recollection is correct or not. It was some time ago.
Yes. My lord, I will do that. I think one of Mr. Bryant and I's colleagues, David Grant, has written an article on this point, although I'm not sure whether his conclusion agreed with me or not, but I will check that and provide that note.
I mean, talking about articles, Mr. Short, I mean, I've started it all off by giving you one, but in response or reaction to the article I wrote, both Lord Sumption and Lord Hoffman have written articles recently in one of the reviews, which take starkly different angles. I think it would be useful on this corrective construction point to see what they say. I mean, obviously, you know, we treat articles with, I was going to say, the contempt they deserve.
I think it depends on the author. I think it depends on the author.
Yes, well, speaking only for myself, it would be contempt, but in the case of the other two I mentioned, it would obviously be respect. No, but seriously, we obviously treat them with a certain diffidence, but I think it is useful to see what people have said, because we tend to think of three cases, you know, the 3 or 4 cases that we've just looked at, and think that's all there is. Whereas the truth is, of course, there is quite a bit more, and there may be some nuance in the other cases or in the articles which helps us. I mean, you know, speaking for myself, I think this is a fairly important point.
My lord, yeah. Well, my lord, I will do that. I have one more authority I was proposing to take your lordship through very briefly, and it may be that, and that's the Stenner case. Yeah. Maybe if I do that, and if we have a short break after that.
Yes.
Stenner is at tab 16. Of the bundle of authorities, that's page 335. It's the decision of, or the judgment of Lady Justice Arden with the agreement of Lord Justice Ryman, Lord Justice Coulson, and it's paragraphs 33 to 35, which are at page 343 onwards, 34 or 33, 34 at the bottom. I'm going to begin paragraph 33, since that refers to the previous passage. That passage was not directed to the situation which arises in the present appeal, where a clause in the original trust deed is adopted again when the deed is revised and replaced by a new trust deed, albeit one containing, to all intents and purposes, the same clause, and the question as to the meaning of the clause is to be asked at the present time. 34, Lady Justice Arden accepted Mr. Spink's submission that even though the very same clause is effectively readopted in the same form, its meaning may change on each reintroduction if the context in which it is readopted is materially different. And then at 35, thus the meaning of a clause which is readopted from time to time has additionally to be considered in the context of circumstances subsequent to the date of its original adoption. It follows that regard should be had both to the relevant circumstances of the date of its original adoption and the relevant circumstances at each subsequent re-adoption. Now, that of course is subject to the Rainy Skywood, other issues of construction, or other cases on construction, which aren't really being dealt with here. And so if the factual background would not permit a different conclusion because the language is unambiguous, that would be the case when the clause was originally adopted and also when it was re-adopted. But subject to that, your lordships have the authority and proposition that the clause has to be considered from both when it was originally adopted and when it is re-adopted.
It would be a very unusual case where the meaning changed, but
yes,
presumably there would be special circumstances in the factual matrix or in the legislative background.
Yes, something of that nature.
I mean, the parties in this case have concentrated on the section 51 point, but pensions legislation was changing quite rapidly with the 1993 Act and then the 95 Act and then amendments to the 95 Act. But I'm assuming that there isn't anything specifically relevant beyond the drafting and then enforcement in 1997 of the 1995 Act and Section 51, the later amendments to Section 51. I mean, somebody referred to my judgment in kinetic and the schedule to that, and I looked at that to try and work out all the machinations of the changes, but I didn't think that they were really very helpful.
No, that's the background, that's the legislative timetable, which may be helpful to understand the way in which pensions have been regulated over the years, but I don't think anyone suggests that other than the specific Section 51 point, that the other changes are material, other than to show.
And you don't say there's anything in kinetic. I mean, I know kinetic caused a bit of a stir when I decided it, and it's now been upheld fairly frequently. But you don't say there's anything in kinetic that goes one way or another here.
No, not on this point.
On the main point.
Not on the main point. There are. I rely on a different part of it in relation to whether it has to be one rate or there can be different rates, which your lordships will have seen. And I take in my submission some support from its approach in relation to the Section 51 point, but nothing beyond that, my lord. No.
Well, should we take a break now and resume at midday?
My lord, yes.
Thank you. Right, well, I think we have everybody. So, Mr. Shaw, please continue your submissions.
My Lord, I'm grateful. I have had the opportunity to look at the decision in KPMG again, in the light of what my Lord Justice Nugee has said, and indeed at paragraph 50 of that decision, which is at page 282 of the bundle of authorities, Lord Justice Carnworth does say this, having dealt with, this is in a section on the correction of mistakes by construction beginning at paragraph 44, he does say the relevance of this point in the present case is that having decided that the 1974 draft lease is a legitimate aid to construction, which was the subject of separate argument, it's wrong to compartmentalise the process of interpretation. Both in the judgment and in the arguments before us, there was a tendency to deal separately with the correction of mistakes and construing the paragraph as it stands, as though they were distinct exercises. In my view, they are simply aspects of the single task of interpreting the agreement in its context in order to get as close as possible to the meaning which the parties intended. That, of course, isn't helpful to the submission I've made, but it does not present an obstacle in my submission to the correction cases, even if they're seen as just part of interpretation, being treated differently in relation to cases where the language is clear and unambiguous and does not permit of alternative constructions. And the Supreme Court judgments in my submission do treat it as being different to that extent. But, my Lord, I will come back to that point, having revisited the authorities as, my Lord, the Master of the Rolls requested.
Yes, and while you're looking at KPMG, the point I was thinking of is at 46, where, having cited the classic statement by Lord Justice Brightman that there must be a clear mistake on the face of the instrument, he says, no, you don't. You can look at anything.
Yes. Yes, so I don't think certainly I haven't intended to limit its application to the four corners of the document.
Yes.
But one still needs, in my submission, to show that there is a strong case of there being an error.
Thank you.
Now, my lords.
I mean, of an error is really the point. In other words, an obvious error, and there's really nothing here, you say, I suppose, that makes this an error as opposed to unwise or bad drafting.
My lord, yes, I wouldn't say it was unwise or bad drafting either, but there was...
No, but I mean, if even on their analysis,
yes.
What's really saying is this is unwise or bad or inappropriate or uncommercial drafting, but that's not a manifest error, effectively.
Yes, my lord, exactly, that's my point. Well, the information provided, the information relied on, says we are going to provide the same benefits, we are going to replicate the existing provisions. That is then done with some care, and particular care, because there are modest cosmetic changes. So the draftsman has plainly engaged his mind, her mind, when dealing with these, when dealing with transposing the terms, and in those circumstances it is impossible to say there is an error in the language. But my lord, I'll come on to that in due course. As I said at the outset, the starting point is the text. Particular weight is to be placed upon the text in a case of this nature where one has a very lengthy, carefully produced, detailed document provided by expert advisors. And the words that require construction, any other rate decided by the principal employer, in my submission, are clear and have the meaning, and only the meaning, of any other rate, which is up or down. Now, I appreciate that saying this is what they mean, it's obvious, is not the most sophisticated submission I've ever made. But it is, I think it's often been observed that it's often difficult to articulate exactly why the natural meaning of words is said to be one thing rather than another. But here, I suggest any other rate is fairly self-explanatory. Any dispute of construction before a court is almost bound to involve competing submissions where each side says, well, if it was meant to mean exactly what my opponent says, then it could have been made more clear. And you get those submissions on both sides and they cancel each other out. But in my submission, that's not the position here, because adding the word higher modifies the meaning. It has an impact on the meaning. Whereas in order to make absolutely clear that it has the meaning that I submit it carries, that could be done in my submission by underlining the word any, simply emphasising what is already there. And so even if that's done by adding whatsoever at the end, it really doesn't modify the meaning. It reiterates, at the very most clarifies, but it doesn't change the meaning, whereas putting higher in does.
But the same would be true, I suppose you would say, if it said any other, i.e. higher or lower rate.
Yes. But and the important word, i.e. is important there, because it simply shows that it's explaining what's gone before. It doesn't change it. No one thing. It is changing the meaning.
Hello.
We're getting a bit of feedback. Somebody's trying to unmute their microphone, which they shouldn't be doing.
Claimant.
I'm not sure. The only person I can see who's not muted is Mr. Moen himself. Mr. Moen, if you can hear, I'm not sure if you could mute your microphone. But in any event, I'll move on. But the essence of my submission is this is not an ambiguous phrase. It is a sophisticated. Yes.
No, you done with it. All right.
I don't think Mr. Moen has his speakers on because he can't hear us. I wonder if someone from the second respondents team. There we are. It's all done. A sophisticated, professionally prepared document, and the wording should be applied in the absence of a strong case that something has gone wrong. Now, my lord.
Can you tell me which, we've just been sent the extract from the BAS Employers Security Plan, and I just wondered which clause was the increases. Oh, is it clause 23, is it?
It is, what if I can have a...
Actually, it's clause 20 on the first one, 46 one. Pension increases.
Yes, it's clause 20, and
it's the second paragraph, my lord, if I've missed this one.
Yes.
Seems to be 4% LPI,
yes,
which is
Clause-
unusual.
yes. But this is pre 1997, so many schemes didn't give any increases. So it was certainly no requirement.
Yes. Sorry to interrupt you, Flo. I just was looking at it.
So, my lord, I was going to move on to the other factors in this case, and given the clarity of the language, I say that the other factors are not, under any circumstances, sufficient to establish the meaning preferred by the learned judge, either because the wording is unambiguous and is to be applied, or because these factors do not point away from the textual meaning, or because they have less weight and are to be given less weight than the text. I'll deal with them in turn, in this order: purposive construction, the factual matrix, and the legislative matrix. But on purposive construction, Lord Hodge made clear in Bernardo's that the emphasis upon language does not reduce the importance of the purposive approach and avoiding undue technicality considering practical consequences. Although the learned judge, in my submission, appears to have elided the question of the purposive approach dealt with by Lord Hodge with the question of the background matrix. And to make that good, if I could ask your lordships to look at page 95 of the PDF of the core bundle. That's page 93, tab 7, page 93.
Have you got a paragraph number?
It is paragraph 73. Where the learned judge says, starting at the end of the second line, in particular, this is a case where no new members have been able to join the Britvic Pension Plan since its inception. But pausing there, that was not been able to join the two defined benefits sections since its inception. And members who did transfer in at its inception had the benefit of explanatory documents. Certain other cases, Mr. Bryant's clause principle will be subject to constraint identified by Lord Hodge in the Bernardo's case at the end of paragraph 16 of his judgment. In the present case, however, that constraint is of limited application. Therefore, it seems to me that in the present case, the need to construe the provisions of a pension scheme so as to give reasonable and practical effect to the scheme, and the preference for a purposive construction are appropriate as opposed to a literalistic one, has rather more force than in the general run of pension cases, where the third, fourth and fifth characteristics identified in Lord Hodge's speech in Bernardo's will have rather more relevance than application. But Lord Hodge drew a distinction between the background facts in paragraph 16 and the purposive, reasonable and practical effect approach, which isn't apparent from paragraph 73 of the judgment. In any event, more importantly, in my submission, the learned judge erred in finding that the any higher rate approach was the more purposive of the two. I say that the higher or lower construction is more purposive in the courage sense because it gives a reasonable and practical effect to the rule in two ways. First, I'll make a submission that looks at the rules as a whole and the role performed by the employer's power. And second, I'll make a submission focused on how the rules are said to work in practice. As to the first, my point concerns the augmentation rule, which is a Rule 4 of the 2003 Britvic deed. It became General Rule 6 in the 2007 deed, but the 2003 deed is in the core bundle at tab 13D at page 145 of the bundle and 149 of the PDF.
Is that the core bundle?
Of the core bundle, my lord, yes. And your lordships have that at the bottom of page 145, Rule C.4. This is taken from the general rules, which apply to both the staff defined benefit section and the executive defined benefit section, but also applied to the defined contribution section, which wasn't populated entirely by those who transferred over, which perhaps underlines the difficulty in siloing particular rules and treating them as only relevant to members of one section or another. But the rule is a relatively typical augmentation rule, and it says, at the request of the principal employer, that subject to payment of any additional contributions the trustees require, after consulting the principal employer and taking actuarial advice, the trustees may A, increase any of the benefits under the plan, or B, provide a benefit to a person who is a current or former employee of an employer, or his spouse or dependent. Now that augmentation rule, I understand it is common ground that it would allow increases above those provided for by Rule 10.2 to be made. And so, although obviously it's a much wider power, various other augmentations could be made, it would allow increases above 5% LPI. And so, if the rule in Rule 10.2 is limited to higher increases, then it adds more or less nothing to that rule. I say more or less, there is still a theoretical rule, because theoretically the trustee may say under Rule C.4, well, you need to provide additional funding to, if we are going to provide that additional increase. But in my submission, the purpose of Rule 10.2 is very unlikely to have been intended to permit the employer to impose unfunded benefit improvements on the scheme where the trustee thought they needed to be supported by additional funding.
And in any event, it would all come out in the wash at the next valuation anyway.
Yes, my lord. Now, I don't say that simply because there's an overlap, it cannot have the meaning suggested, because it is impossible to expect a perfect tessellation of scheme provisions with no overlap anywhere. But the higher or lower approach does give a perfectly sensible and practical additional role that is not available under the higher rate construction. The second point under this heading is to say it's more straightforward and more practical than the what I say with respect, is the unnecessarily complex and technical two-stage process that underpins my learned friend's submissions. Because taken as a whole, in colloquial terms, if the scheme was flush with money, difficult to see why the employer shouldn't be able to say, happier financial times, we will pay 5% increases from now.
You say if the scheme is flush with money.
Yes.
This scheme is over 100% funded on the technical provisions basis, which is quite a prudent basis. So why is it not flush with money?
Well, because that's technical provisions. And if one now said we're going to pay much more than the CPI or RPI, one wouldn't be flush with money for very long. Lots of schemes have very...
Can I ask, do we know what the employer's intentions are if it succeeds? It obviously doesn't affect the question of construction, but just a matter of interest.
The employer has made clear that in general terms it considers CPI to be the more appropriate measure than RPI. However, there are historical issues, and the employer has exercised its power, purported to exercise its power, to reduce the increases in 1 year, I think, to 1%. I don't think the power was exercised last year because of particular circumstances, which meant there was really very little in it. It's not an entirely academic question that's being asked.
Well, no, if you succeed, then subject to any legacy issues, you'd be entitled to reduce it and to the statute to zero.
Yes. Well, that's the position. It's not the intention to do that, but it is the intention to at least know and to use the power if it exists.
Thank you.
But if a scheme was so flush with money it needed to reduce its surplus, for example, which may have been the position in 1997 when this rule was originally introduced, then it's difficult to say why shouldn't an employer be able to say, well, we'll pay 5% from now on. Why should they have to wait each year for the trustees to make a decision and then make a decision after that? Similarly, if there are financial difficulties, they can, and if the employer is able to limit payments, then subject to statutory protections. And again, when this rule was originally introduced in 1996, none of the benefits at that time were entitled to statutory protection. But if it can be exercised downwards, it's difficult to see why that shouldn't be done for several years in advance. It's said that this would subvert the 5% LPI figure that appears in the rule. But in truth, it simply means it would replace or substitute a figure for the 5% LPI figure, and that is exactly what the language of the power suggests it is intended to do. The suggested division of labour between the trustee and the employer is only necessary if the second respondent's construction is correct, if the trustee need first to apply the 5% LPI figure, and then the employer has to top up. Now, there's nothing inherently attractive or sensible about that arrangement, because it makes duplication inevitable whenever the power is exercised. I accept that my construction provides less protection against inflation than my learned friend's construction. But the purposive approach is not one that provides as much protection as possible, because the question of construction is intended to identify how much protection is offered. And there is no assumption, no philosophical disposition that requires a more protective rather than less protective analysis to be taken. But for those reasons, I say the purposive approach, bearing in mind what the power would add to the other rules and how it can be exercised in practice, those factors support rather than contradict the textual meaning.
And I think somebody said when interpreting a pension deed, you don't start with the assumption that the interpretation is either in favour of members or employers.
My Lord, yes, it's Lady Justice Arden in Stevens and Bell, the BA case.
Yeah.
I'll give your Lordship the paragraph. Now, in fact, I'll do that now. It's used to be the starting place for construction of pension deeds. It's been rather superseded by Bernardo's, but on this point, I don't think there's any suggestion it's no longer right. That's tab 9 of the bundle of authorities, and it's Lady Justice Arden's judgment beginning at paragraph 26, which is at page 180. And it's the 5th of her principles at paragraph 31. So 5th, at the end of the day, however, the function of the court is to construe the document without any predisposition as to the correct philosophical approach. Both sides urged on us their respective philosophical approaches. Mr. English-Jones submitted the overall approach of the APS trust deed was favourable to members. BA submitted, it should be remembered, this was a balance of cost scheme. In fact, there was a surplus, meant the employer had paid too much. And then there's a reference to the effect of it being a balance of cost scheme. But it is simply, it's the function of the court to see what protection there is, not to approach it on the basis that it should offer more rather than less protection. I'm going to move on.
Just before you move on, then, Mr. Short, at some stage, are you going to tell us what your answer is to the point that if that was what the scheme was intended to do, gives the employer free hand to choose whatever rate it wanted from 0 to whatever, why is there a reference to 5% LPI at all? Why doesn't it just say it shall be increased each year by such amount as the employer decides?
Because it allowed the trustees to increase it by 5% LPI year after year if the employer didn't exercise that power.
So it provided a default regime.
Yes, without using the word default in too technical a sense, because obviously that's raised elsewhere. But one either got the express rate or the employer's rate. The members had a right to the 5% LPI or the rate fixed by the employer. But the employer knew that if it didn't do anything, the member would get 5% LPI. The trustee knew that they wanted funding for 5% LPI unless there was a suggestion that something else was to be done. It was a very helpful rule And certainly as introduced by the BAS scheme, it was a very generous rule. And it serves a perfectly good purpose, which has operated for many years.
It also imposes not a financial cost, but a relationship cost on the employer, because the employer has to positively decide to impose a lower increase if it's going to do so. Whereas if it was left to the employer to choose to rate every year, the employer would have to do it every year.
Yes, there are industrial relations consequences to that. Certainly from 2006, there are where there's a reduction in the rate, there has to be consultation. So it works by allowing everyone to know what's going to happen, unless the employer exercises this power, and the employer has not exercised that power, or did not exercise that power for many years.
Thank you.
Now, I'm going to...
Forgive me, Mr. Short. I'm sorry, forgive me. I just was fiddling around and not unmuting. I thought when my lord asked you about increases, I thought I read somewhere that there had been an agreement that they would exercise the power and impose a 1% increase in place of the
Yes.
LPI 5%. What was that? When was that? And why was that?
Yeah, my lord, I hope that's what I said, that the power had been purportedly exercised.
Right.
1%.
And when was that?
And that was, so I should know this, it's in the supplemental bundle.
It's tab 20, I think.
Yes, the agreement is at tab 20, page 330. The difficulty, of course, was the power was going to be exercised at a time when it wasn't clear what the power did, or it was said not to be clear that the power allowed them to do this. But of course, if it wasn't exercised at that time, then it couldn't be exercised retrospectively once the increases had been awarded. And so it is, the power was exercised in 2019.
And that is presumably, I think there was a court order
Yes.
permitting it, but it's presumably provisional on you winning the appeal.
Yes. Effectively, yes.
Yes.
Yes, it was approved as a compromise by Chief Master Marsh in August of 2019, and the order's at tab 21, which has, it's quite a complicated interim agreement which deals with how it gets unwound and what's done and how it was implemented. But
Thank you.
Your Lordship's quite right, it was exercised at 1%.
And that exercise wasn't repeated in 2020. So the 2020 increase is the 5% LPI, is that right?
My Lord, yes, I believe that's right. There was no material, no very significant difference between CPI and RPI last year because of the extraordinary circumstances.
Yes, and they were both quite low.
They were both very low. Yes. Now, moving to the factual matrix, I made 2 points. First, in my submission, the learned judge erred in purporting to distinguish Bernardo's, and secondly, he erred in treating the facts he identified as establishing the higher rate construction. And you can see where he departs from Bernardo's in tab 7, paragraph 73, which is at page 95 of the PDF, page 93 of the bundle.
That was the passage you showed us before.
Yes, my lord. And also at paragraph 134, which is at page 103 of the bundle, page 105 of the PDF. Where he refers back to his earlier comments. He says, I've already indicated I accept Mr. Bryant's submissions, the fourth and fifth of the specific distinctive characteristics relevant to the court's interpretation of pension schemes identified by Lord Hodge in the Bernardo's case had no application in the instant case. Not a case where the scheme confers important rights on members of a pension scheme who are not parties to the original instrument and who may have joined the scheme many years after it was initiated. Not a case where members of a pension scheme lacked easy access to expert legal advice or were unable readily to ascertain the circumstances which existed when the scheme was established. Potential members of the new Britvic scheme were already in existence, readily identifiable, sent letters and other documents explaining features of the new pension scheme, invitations to transfer into it, and reliance upon which they elected to effect such transfers. It's plain in my submission that he is distinguishing Bernardo's in order to give more weight to the factual matrix and less to the text. That, in my submission, is inappropriate generally in a document of this nature, but also on the facts of this case, there's no warrant for moving away from the text to this degree. The first reason for that is that many of the factors obviously did apply, the non-pension specifics, namely that this was a sophisticated document produced by expert advisors which dealt expressly with this issue. It is true that the members had previously all been, the members who were directly affected were all existing members of the Bass Six Counties scheme, but that doesn't meet the objection, because there would still have been people who would have found it difficult to identify the relevant terms or the relevant circumstances. Lord Briggs refers to family members who obviously wouldn't have been party to this provision, or a provision of information. Those deferred members who were being transferred without consent wouldn't have been party to this information. The scheme always had a power of amendment which would have allowed new people to be introduced, and it's heretical to suggest that subsequent events should affect the construction. And the only way to avoid that happening is to deal with the nature of agreement rather than the particular effects. And it's not appropriate to depart from the Bernardo's approach simply because some members would have received some letters. Now, it's not realistic to expect members of a scheme, even if the letters have gone to everyone, not realistic to expect members of the scheme to keep letters 20 or so years after they're provided with them. Those with experience of the administration of pension schemes will find that the schemes often haven't kept all of the documents relevant to the construction of a particular, of the governing provision. And so that is one of the reasons why Lord Hodge has said that the deed is what the governing provisions are what need to be construed. It's no answer to the, it's no answer to refer to the disclosure regulations, as my learned friends have done. These appear in the authorities bundle at tab 37, page 753. I'm also keen to turn my mobile phone off. I forgot to turn my actual phone off, which I'm afraid has been ringing. Yeah, they are at tab 37 of the authorities bundle. Page 753. These are it's a statutory instrument which gives members of a scheme and their trade union representatives the right to obtain certain documents and information relevant to a pension scheme. These are the regulations that were in force at the time of the deeds themselves, certainly the 2003 deeds. They've been amended since to become much more complicated, but they're still in the same essential form. And what they do, what they give are two different rights, really. Regulation 3 gives members and trade unions the right to the content of the trust deed constituting the scheme, or any other documents constituting the scheme if it's not constituted by a trust deed. The rules are not set out in the trust deed or other documents, then the rules themselves, and the contents of any document which amends or supplements those rules. And that's really the right to documents. So a member is able to obtain the trust deed, the rules, amendments of the deed. They do not have a right to any of the background documents. And so this, in my submission, very much supports Lord Hodge's approach, because the one thing that the members can get is the deed, and they can take a view on the words of the deed. They do not have a right to background information. There is a right at paragraph 4, under regulation 4, basic information about the scheme, and that is to information set out in the schedule, but that's really only about conclusions rather than background documents. So, for example, they can be told the accrual rates, eligibility criteria and increases, but they don't have any right to the background documents. And so the fact that many of the members, all of the members of the scheme were already members of the scheme doesn't provide any sufficiently good reason to depart from the general guidance in Bernardo's and to depart from an approach whereby the text is of more weight. Second point is, in my submission, the background material does not support, let alone justify, the conclusion that was reached. And so two pieces of information are relied on in particular. One is the information that was provided to the active members before they transferred in, and the other is the information in the transfer deeds that were entered into in March 2003 after the deed and rules had been made in January. I'll deal with them in turn. The information provided to members of the what was to become the staff section, this is members of the ordinary 6 counties plan, is set out in the supplementary bundle at tab 15, which is at page 247 of the bundle, page 250 of the PDF. Now there's an earlier letter which says similar things, but this is the more important of the two. It's 17th of December 2002, and what is important, I say, is someone is told that they can join the new scheme with effect from 1st of January 2003. And the third paragraph down says the Britvic plan is being set up to provide the same benefits as currently provided by the Six Continents plan. These are summarised in the enclosed outline benefits summary. So the same benefits is obviously what I rely upon there. The benefits summary is at page 249 of the bundle, page 252 of the PDF. However, it's landscape, I'm afraid.
Before we look at that, Mr. Short,
Yes.
This is the letter which went to active members.
I believe so.
Well, if you look at the top of page 248, it does say your benefits will be continuous and so on. And it's giving people an option. Was there anything that went to deferreds and pensioners saying your pension's been moved to a new scheme? Is there any evidence on that?
I'm not sure there is any evidence, my lord. No, it was a compulsory bulk transfer for others. There was one particular category of member that wasn't transferred because there were perceived problems with doing that. But I think...
Yes. You answered a question from me earlier that it was a non-consensual bulk transfer. I understand that. But quite commonly, if you are moving people from Scheme A to Scheme B, you tell them that's what they've done, so they don't get alarmed that they're getting pension statements from somebody different.
Yes. Well, my lord, I don't believe that any such information is said to have shed any light on this question. So I can't give your lordship an answer. But
all you can do is answer whether there's any evidence.
I don't believe there is. There's none in the bundle before your lordship.
That's what I saw. Thank you.
And yes, my lord, I lost my place. Page 252 is the 249 of the bundle, 252 of the PDF has the outline benefit summary, and it says in the in bold at the top, this document is intended as a preliminary announcement summarising the main benefits and contributions of the DB section of the new plan. This summary applies to members of the DB section of the Six Continents Pension Plan who transfer their membership on the 1st of April by electing to do so before the 1st of February 2003. Benefits and contributions replicate the current terms of the DB section of the Six Continents Plan. Obviously, the word replicate is powerful. As a summary, it cannot include every detail. The trust deed and rules of the Britvic plan will set out full particulars of the benefits and conditions on which they are payable, and will take precedence in the event of any discrepancy between this or any document and the trust deed and rules. This document has been approved by Six Continents PLC and the trustees of the Six Continents plan. So whether that I say is important. Pension increases are dealt with on the next page, 250. of the bundle. And they say guaranteed increases, pensions in excess of any guaranteed minimum pension are guaranteed to be increased each 1st of October in line with the rise in retail prices index for the year ending 31 May, preceding the review date up to a maximum of 5%. GMP earned after the 5th of April 1988 are guaranteed to be increased each year in line with the rise in RPI up to a maximum of 3%. Then there's a reference to discretionary increases. Trustees and company intend to pay additional increases on the pension in excess of GMP of 2/3 of the increases in the RPI of 5%. These increases are not guaranteed. That was perfectly accurate in practice to 2019. It does not say that there is a power to change that rate, and it is not complete for that reason. There is a reference at 253 of the bundle, 256 of the PDF under general to the company having the right to terminate contributions or, with the trustees' agreement, alter the benefits it provides. However, benefits related to past service are protected by legislation. There could also have been a general proviso dealing with powers to make changes, but I accept it is not complete. But that is why one has the disclaimer saying this is a summary, and that is why disclaimers are almost always found when there are documents summarising benefits, either in a booklet or documents of this nature. Now, in fact, pretty much these terms already appeared in the BAS scheme booklet, which is in the...
Before you go to that, Mr. Short, my note is you said that this was accurate but not complete. But it says that there are guaranteed increases. It draws a contrast between guaranteed increases and discretionary increases.
Yeah.
But on your submission, the guaranteed increases are not guaranteed at all because they can be taken away at any time.
They're guaranteed unless the power is exercised.
That's not a guarantee. That's not a guarantee. I mean, to the layperson,
yes,
reading something saying guaranteed increases, pensions are guaranteed to increase on each 1st of October, would mean from now forever.
yes.
It wouldn't mean until we change our mind. That's not a guarantee.
My lord, yes. Similarly, the reference to your benefits will have a normal retirement date of 65, would mean people would think they would have that right. Whereas, in fact, that could be changed for future service. And that should have been explained. But no, my lord, I accept that is not a helpful statement in the terms of this, given the terms of this scheme. But it is no more than what the author of the document thought the rules meant. It doesn't change what the rules mean.
But that I think is a submission that even if inaccurate as well as incomplete, it doesn't matter.
Yes.
Yes.
My lord, yes. But particularly in the light of the statement that it was a summary and would take, and that the deed would be, would take precedence, but more importantly, that it was going to replicate the existing benefits. As I mean, I do think it's helpful to look at the BAS
Yes.
split in these circumstances. This is in a supplementary bundle, tab 9, and it's pages 197 and 198 of the bundle, pages 200 and 201 of the PDF, and 197, first of them, sets out a summary of the rights to increases.
What's the date of this document?
1996. I think that's right.
It says April 1997 on page 199.
Your Lordship's quite right. 1997. It was after the 1996 deed. And your Lordships will see that the second and third paragraphs on page 197 have language that is very similar to that appeared in the subsequent document summary, benefit summary sent out in 2002. And then at 198, one has exactly the same, or the usual proviso, trust deed and rules. This handbook is intended to provide a general guide to the BAS plan, and although every effort has been made to ensure the contents are accurate, it cannot include every detail. Should there be any discrepancy between the information in this handbook and the trust deed and rules, which are the legal documents which govern the BAS plan, the trust deed and rules take precedence. Trust deed and rules are available for examination. Now, in my submission, the learned judge erred in his approach to the information provided to the members, and one sees this at paragraphs 130 and 131 of the judgment, which is in the core bundle, tab 7 at page 103 or 105 of the PDF. And at 130, he says, I acknowledge, of course, it was made clear in the prefatory statement to the outline benefit summary that it could not include anything detail. Trust deed and rules of the Britvic Pension Plan were to set out full particulars of the benefits and conditions on which they were payable, and were to take precedence in the event of a discrepancy. But the document was said to have been approved by 6 Counties PLC and trustees of 6 Continents Pension Plan. It was intended to give a fair summary of the benefits and conditions applicable to pensions under the proposed pension plan. I do not consider that the draftsman intended it to be in any way tricky or misleading. In my judgment, it is powerful evidence of what the draftsman of the outline benefit summary and of the proposed Britvic pension plan intended that plan should provide. Pausing there, insofar as that suggests that the draftsman was the same, there's no evidence for that, and I don't think that's suggested by my learned friend. But even if it's talking about 2 different draftsmen, the conclusion is unsustainable if it suggests there is an intention to provide different benefits to those available under the previous deed, because there is a clear statement that the summary is just that, a clear statement that the new rights will replicate the old, and there is no basis for assuming that the draftsman of the 2003 deed was intended to give effect to the summary rather than the deed, the 96 or by then 2002 deeds, that he was intending to replicate. And so it, in my submission, cannot be said that that supports, on an ordinary construction basis, the idea of the rights in 2003 changing from those that already existed. Nor does it support any conclusion that something has gone wrong with the language, which is something that the judge deals with at paragraph 131, but bearing in mind the time, it may be appropriate for me to deal with that at 2 o'clock.
Yes, that's a good idea. We'll resume at 2 o'clock. Thank you, Mr. Shaw.
My lords, I'm grateful.